criminal appeal against conviction in a vigilance case, sentenced to 2 years.
Madam, let's see video specific urgent matter.
Yes, on 30th 11, I had made a mention that letter received from the jail authority to engage the order network. The letter is already old. It's not listed. Your Lordship directed to verify and
it will be listed tomorrow, Mr.
May I please, Your Lordship?
The patient suffering for stage 4, my lord. He need a kidney transplant or dialysis, my lord. Last Monday, Your Lordship called for report, my lord. Your Lord specific director listed today, my lord.
Give it.
May I please, Your Lordship? Misinterpreting the bail order passed by this honorable court, the learned court below refused to take property security and issued a warrant against me, Your Lordship. The matter was mentioned before Your Lordship, and Your Lordship has fixed to today, and it was not listed. Can I pray for tomorrow? Can I pray for tomorrow?
Please give it.
This is a bail matter for bail. The bail matter, my lord, was listed prior to vacation, my lord. Some puja vacation. And Lordship is directed to list the matter.
Lordship granted bail to the juvenile, imposed a condition that family. I filed a modification of the order. You Lordship granted bail.
Okay.
Yes, appeal matter. Conviction is 7 years out of 6 years.
To make mention, my lord, one criminal division for vigilance, my lord. The petitioner is a doctor, my lord, and the wife of the petitioner has a name in the affair, but the petitioner name is not in the affair, my lord. The vigilance already sees her, the presumption has sees his LIC documents and bank accounts, my lord.
Oh, what is the urgency?
And he has already seized their documents, my lord.
It will come after.
Urgent bail matter, offense tribunal magistrate and offense tribunal magistrate and co-accused person already granted bail by this.
Bail matter. Give it.
Your Lordship, I may be pardoned to make a mention, Your Lordship. Your Lordship had granted me an interim bail for a period of 3 months. In the meantime, Your Lordship, my mother has been detected with cervical cancer. I'm praying for an extension of interim bail as the...
Give it.
Out of 10 years, my lord, 8 years, 8 months in custody, posted to today. It was not listed.
Yes.
I have filed for leave to continue the appeal. This whole appellant died. I have filed for leave to continue.
What is the urgency before that?
Okay,
list it after.
I may be pardoned. Today's list item 100. It was in the list on Friday. That when it was about to reach, when its state council said that the CD is misplaced. But today may not reach, may be taken up by.
Why it will not reach?
It's easily reach.
Yes.
Weekly list item number 1.
special vigilance case number such and such. Also, we can see page 46. Page 46 is sentenced to undergo duration for 2 years and 5,000. The PC prevention of corruption.
Wait. Surendranath Mishra is sentenced to undergo rigorous imprisonment for 2 years also. Yeah, you were on bail during trial?
Yes, since 2010, my lord.
Yes, Mr. Das.
Yes, my lord, I have received the copy. I will file my appearance memo by the end of January 2024.
All right. Heard Mr. Sanjay Kumar Das, learned and standing counsel for the Vigilance Department, who submits that he has received the copy of the appeal memo along with the impugned judgment, so also the copies of the interim applications. Heard admit call for the trial court record. He was on bail allowed, stay realization of fine. The name of Mr. Das be reflected in the cause list henceforth, and free copy of the order be handed over to Mr. Das. Please to come.
All right.
And, please to file the appearance memo by January 2024. Okay.
Item number 3.
Madam, stay of the sentence.
Item 4.
Yes.
Please, Your Lordship. Plus, the appellant has been convicted under section 13(1), 13(2).
What is the operative part?
At page 68, internal page 56, para 73.
6, no?
Para 73.
For 2 years.
Sentenced to rigorous imprisonment for 2 years and to pay a fine of 10,000 in default to undergo RI for 6 months for the offences under section 13(2) read with 13(1)(d) of the PC Act, and further RI for 1 year and pay a fine of 5,000 in default to undergo RI for 3 months.
You were on bail during
trial.
Yes, Mr. Das.
Yes, my lord, I have received and I will file the same order January 24. My lord.
The same order you mentioned is the item number 2. Admit bail allowed. He was on bail, so stay realization of fine. Baki jaha likhithile seha likh debe. Next.
Great.
Item number 5.
May I please? The appellant is a lady. He has been convicted under section 13(2). Running page 43 of my brief. She was on bail during course of trial. She has never received trial.
You were on bail during trial.
File.
Yes, Mr. Das.
I have already filed my appearance memo on 8/12/2023 in this appeal.
The Mr. Sanjay Kumar Das, learned and standing counsel for the Vigilance Department, submits that he has already filed his appearance memo on 8/12/2023. The registry shall place the same on record. I'd admit call for the trial court record. Bail liquid, he was on bail during trial and after conviction by the London trial court, she has been taken into judicial custody. Bail allowed, stay realization of fine. Like the rest of the order, like the previous.
Free copy.
Yes, free copy.
Item number 6.
May I please, Your Lord. Appeal against an order of conviction, my lord. Operative person at page 69, my lord, para 2. Has been convicted of the offense alleged, that is 13(1)(e), read with section 13(2) of the PC Act.
Disproportionate asset case.
Yes, my lord. Arrived for 2 years and fine of rupees 10.
You are on bail during
Yes,
trial.
yes, I was.
Mr. Das,
Yes, my lord, I have received. I will file my appearance by the end of January 2024, my lord.
same order like item number 2 and 4. Bail allowed, admit, stay realization of fine. Yes.
Item number 7.
May I please, Lord. I am appealing. Conviction is on section 13(2), read with section 13(1)(d) of the PC Act.
Give it to Mr. Younger. Yes. Do it.
75.
Lordship,
What is the running page you had the operative one?
Lordship, page 75.
Hmm.
Of,
Yes.
the appellant has been convicted and sentenced to undergo for array for 3 years for offence under section 13(2), read with section 13(1)(d) of PC Act and fine of rupees 5,000 and in default to undergo array for 2 months.
Okay. You are on bail during trial.
Yes, Your Lordship.
Yes, Mr. Das.
Yes, my lord, I have received and the same 2024 end.
Okay.
I will file my appearance memo, my lord.
Admit like item number 2 and 4. Bail allowed. He was on bail. Stay realization of fine. Yes.
And free copy of the order.
Free copy.
Item number 8.
May I please, my lords. My lords, the operative question is at page 58, running page, conviction for 2 years and fine of rupees 10,000. Under section 13(1).
And you were on bail during
My
trial.
lords, my lords.
Yes, Mr. Das.
Your lordship has already admitted CRL 1332 on 11/12/2023 of the co-appellant,
Okay.
and LCR has been called for in that matter, my lord.
You will file the appearance memo
By the end of January, my lord. January.
admit call for the trial court record. He was on bail, bail allowed, stay realization of fine. Mr. Das submit that the connected criminal appeal is CRLA number 1332 of 2023. And trial court record has already been called for in the said case. The registry shall verify about the availability of the trial court record in CRLA number 1332 of 2023. Henceforth, the matter shall be listed with swan matter. Free copy of the order be handed over. Yes, next.
Obliged.
Item number 9.
May I please? Conviction 3 years, my lord. 5,000 rupees fine.
Page relevant page.
Page 26, my lord.
Okay. You were on bail during trial?
No, my lord, I was not on bail. Just now he is released an interim bail for period of 1 month, my lord.
Yes, Mr. Tripathi. Admit. So far as the bail application is concerned, the London Council for the appellant submits that petitioner submits that the petitioner was taken into judicial custody on 16/4/2022, and during trial he was not released on bail, but after conviction he has been released on interim bail by the London trial court. Bail allowed, stay realization of fine.
I may be pardoned, my lord. Item 8, vigilance matter, ma'am.
No, it's that is already over, Mr. You said that it has to come along with CRLA number 1332 of 2023. That is item number 8.
Item number 7 re sei matter ta koili. Item number 7.
Not in 8.
No. Item 8 is another matter. Item 7 re 1332 1333 ଆଉ ଗୋଟେ ଫାଇଲ ହେଇଛି.
ନାଇଁ ନାଇଁ
item
ନାଇଁ
7
ଆପଣ ଯେତେବେଳେ ସେଇଟା ତ ସରି ଯାଇଥିଲା ଅଲରେଡି 7 ନମ୍ବର ଆଇଟମ ଏଇ ଯୋଉ
ନା
1332 ଟା କୋଉଥିରେ ଆସିବ ଖାଲି ମତେ କୁହନ୍ତୁ
1333 my lord 1333 ରେ ଆସିବ 1332 ଟା
ଓକେ
ଆସିବ
ଓକେ
1333
all right
ସେଣ୍ଟରେ
all right all right ବାକି this 1335 of 2023 admit bail granted stay realization of fine
and file my appearance memo by the end of
ओके ये
January.
जो आइटम नंबर 7 रे सेटा लिखि देबे हला ओके यस
Obliged, my lord.
May I please? Appellant convicted under section 13(2) reduced 13(1)(d) of the PC Act and sentenced to undergo 2 years running page lordship the running page 44.
sentence under article 2 years and 5,000 counter reproduction separation. Yes, Mr. Das.
Yes, my lord, I have received and I will file my appearance by the end of January 24.
You are on bail.
Yes,
stay.
Yes, my lord.
Admit. You are on bail. Bail allowed. Stay realization of fine. Rest of the order like item number 2. Yes.
And all the above matters free copy be granted, my lord.
Item 11.
Okay.
Yes.
May I please, Your Lordship, ma'am? This is appeal against conviction, my lord. Conviction for 7 years, ma'am.
What is the operative part of the judgment?
33, page 33, my lord.
Okay. Hard admit call for the trial court record. Interim applications for bail and stay realization of fine to be considered after receipt of the trial court record. Deposition copy to be supplied.
I've already annexed, my lord.
All right, shut up. Yes. Next.
Item 12.
Please.
Till 2023, where the appellants are convicted for 6 months.
What is the operative part of
Page
the
number 40, Your Lordship. SI for 6 months.
Just a minute. Yes.
SI for 6 months and to pay fine 1,000 each for section 147 and 148, and SI for 1 year and to pay fine 1,000 each for section 324 and 149.
Okay. You are on bail during trial.
Yes. All are bail on bail.
How many appellants are there?
There are 6 appellants. Your Lordship.
Okay. What is your name?
Aishwarya Das.
So take down the name and admit. Was in bail allowed. Stay realization of fine. Take the name in a slip. Yes, next.
Item 14.
Yes, may I please, Your Lordship, conviction under
No
section
copy has been served, my lord.
32 of the PC Act, my lord.
You have
Running-
not sought any copy on the Land and Vigilance Council.
No
my
copy
lord,
has
I have
been
already
served.
sought.
No, my lord, not yet.
କାହାକୁ ଦେଇଛନ୍ତି?
କାଉଣ୍ଟରରେ ଦେଇଥିଲି ମୋ ପାଖରେ ରସିଦ
କାଉଣ୍ଟର ମାନେ ତାଙ୍କର
Counter
vigilance
ଆମର ନାହିଁ।
ଆଜ୍ଞା
ଆପଣଙ୍କର କଣ କାଉଣ୍ଟର ଅଛି କଣ କୋଉଠି ସେଠି ଦେଇଛନ୍ତି ବୋଲି କହୁଛନ୍ତି?
ଆମ କାଉଣ୍ଟର ମୂଳରୁ ନାହିଁ, ଆମର ଜଣେ ଏଏସ୍ଆଇ ଅଛନ୍ତି, ସେ ରିସିଭ୍ କରି ଗୋଟେ ରସିଦ ହାତାହାତି ଦେବେ।
ଦେଇଛନ୍ତି ରସିଦ ମତେ।
ଆମ ଭିଜିଲାନ୍ସ ଟା ବାର କୁ ଲାଗିଛି ରୁମ ରେ, ଆମର କିଛି କପି ରିସିଭ୍ କରୁନାହାନ୍ତି। ରାଦର 1368 ଗୋଟେ ରିସିଭ୍ ହେଇଛି କାଲି ପରଦିନ ଶନିବାର ଦିନ।
କପିଟା ଦେଲେ କାଲି ଆସିବ, କିଛି ଅସୁବିଧା ନାହିଁ। ସେ ପାଇନାହାନ୍ତି, କମ୍ପ୍ଲେନ କରୁଛନ୍ତି।
ମୁଁ 8ଟା ଯାକ କଲି ଆଉ।
This matter will be taken up tomorrow. You give the copy or see that the copy reaches at least Mr. Das. If you have given it, just intimate, send the message to Mr. Das that this fellow has received the copy and this is the proof of that. Okay.
Yes, Your Lordship.
ଏଇଟା କାଲି
Our office is attached to my lord bar,
Okay.
High Court bar.
Since Mr. Sanjay Kumar Das, London Standing Counsel for the Vigilance Department, submits that he has not received the copy of the appeal memo along with the copies of the interim application, let the London Counsel for the appellant supply the same to the London Counsel, Standing Counsel during course of the day, matter to be listed tomorrow. এটা টি আগে করে দেবে, হ্যাঁ?
Obligement.
Item 15.
The appellant has been convicted under section 20B2C. The relevant portion is at page 47 of the judgment. I have been sentenced to undergo RI for 12 years and fine of 1 lakh, and further undergo RI for 6 months in default. Page 47, middle para.
Okay.
Admittedly, there is no criminal antecedent.
Admit call for the trial court record, interim applications for bail and stay realization of fine to be considered after receipt of the trial court report. Deposition copy to be supplied to the London Council for this.
So, I am supplying the copy of the deposition today.
Copy supplied in court. Okay.
I'm grateful for that.
Item 19.
There are two matters. I am appearing in the second sub-item. Arises out of the same case. In the first sub-item, if your lordship sees the previous two orders,
What is this matter for?
That's
This bail matter, no?
the bail matter means SC/ST Act.
So notice sufficient?
Yes, Lord. Notice sufficient, 2022.
Okay.
And my Lord,
What was the weapon used for assaulting the deceased?
Blunt weapon.
How many injuries have been caused to the deceased?
Multiple injuries. It is not visible matter to him. Multiple injuries are there.
So, how many persons have been charge sheeted? Because he has not named other person, but said that it is these two persons along with others.
Accused Jitendra Polli.
5 persons.
Anybody has been released on bail in this case?
Yes, sir. 2 accused persons have been released on bail by this honorable court. And I am on. I'm just giving the copies.
Yes, pass on. What about the criminal antecedents, Mr.
Jitendra. Actually,
In fact, my lord, the 2 eyewitnesses, one being the informant, they are to be examined tomorrow. That is my instructions. Because on the last date is my.
How many eyewitnesses are still left behind?
2 more, my lord.
Who are they? One is informant. Yes.
No,
Yes.
Basanti Naik and Rajeshwari Naik. Basanti Naik and Rajeshwari
Right.
Naik.
Rajeshwari Naik is
So
the.
there was a direction actually on
My lord.
15/11/2023.
My lord.
But due to the illness of kahar illness, man say witness manakar illness.
ଏବେ ତ ଯୋଉ 15-12 କୁ ଥିଲା court is not available. ଯେ Khalicourt is on training. Khalicourt is on training. Date was fixed to 15-12 to depose the evidence of Basanti and Rajeshwari, but on mentioned date, Honorable ADJ Khalicourt is on training.
Now he is telling that it is posted to tomorrow.
My lord.
So let us wait and see that.
My lord.
The London Council for the appellant files the bail order copies of 2 co-accused persons which are taken on record. He submits that 2 eyewitnesses namely Basanti Naik and Rajeshwari Naik are to be examined, and the case is posted to tomorrow in the trial court for recording their evidence. In view of such submission made by the London Council for the petitioner, put of this matter after ensuing Xmas holidays, if the 2 eyewitnesses are examined, the London Council for the appellant shall produce the certified copy of their deposition. This you mention in CRLA number 789 of 23, and list this matter would come with the CRLA number 563. 563 रे किसी order क्रिया दरकार नहीं. Yes.
May I pray minutes in the reopening week?
No, it will be, you will see the diary and accordingly give it. It will come.
Oh, bless. Item 20.
May I please? Let us follow.
In this case, CD is there. It is a 307 case. Injured statement and injury report is not available. I talked with the SDPO as well as ISA Bulla manner. We
have you got those two documents, the statement of the injured and the injury report?
Yes, my lord.
The pass on, is it a certified copy?
No, police paper, my lord. Yes, my lord, certified copy.
Then pass on. देखो ना कौन statement है? It's all right. It has been supplied to them by the trial court, the magistrate. Injured statement or injury report as well. What is the date of custody?
Custody since 16/10/2022, ma'am. 16/10/2022.
Charge sheet under section?
Charge sheet under section 395, 307, 324, 120B, 3 of ACSP Act, ma'am.
Charge sheet under section 120B, 395, 397, 397, 307, 294, 320.
Just a minute. 307,
294, 323. Read with 31RS. 32VVA.
P1RS. I would have
32VVA.
120B ଅଛି ତ?
ଆଜ୍ଞା.
Okay.
Reopening also, I am not found at a reopening also.
All right. One more thing, my lord. This person has 7 criminal antecedents.
All right, I'm mentioning. The learned counsel for the state submits that though he has received the case diary, but he is yet to receive the statement of the injured, so also the injury report. However, on verification of the case diary, submits that the appellant Rinku Maji has got 7 criminal antecedents.
Including this case, my lord, 6.
Let the learned counsel number order let the learned counsel for the appellant obtain instruction about the status of such cases and file a comprehensive affidavit relating to the same, giving copy to the learned counsel for the state. Yes.
I have served a copy. I have submitted a copy of CA.
CA?
Daily.
Acha, CA copy has been filed, which is taken in the
Item number 22.
Yes, Mr. Rautran. Notice sufficient,
Yes, my lord, on 3/12/2023.
and you have
Sorry,
received the case
13/12/2000. Sorry.
13 ହେଲେ ସପ୍ତାହ ହେଇନି। Maybe go to after. You have received the case diary?
My lord.
Alright.
What is the
What is the
rejection
offense here?
order of 302, my lord?
302.
Rejection order of 2022.
Alright, after learned counsel for the state submits that the notice has been made sufficient on the informant only on 13th December 2023 in order to enable the learned informant to engage counsel, if any, to oppose the application for the food of this matter immediately after the ensuing Xmas holidays. If any learned counsel enters appearance for the informant, his public health name shall be reflected in the cause list. Yes.
The one thing that but 8 years in custody.
ଆସି ଯାଉଛି 3 ଦିନ ତଳେ ହେଇଥିଲା 2 ଦିନ ଛୁଟି ପଳେଇଲା ଆଉ ଜମା 2 ଦିନ ସେ କୋର୍ଟ ଆଜି ବି ଯଦି ଫାଇଲ କରିଥିବେ କେମିତି ହବ ଆଉ ଟିକେ ସମୟ ଦେବ ନା ୟେସ୍ ନେକ୍ସଟ
ପୋଷ୍ଟ ନୋଟିସ ଯାଇଥିଲା ବୋଥ ୱେଜ ରେ ଯାଇଥିଲା
ସେ ତ କହୁଛନ୍ତି ନୋଟିସ ହେଲା ତ ୟେସ୍ ନେକ୍ସଟ
Item number 24.
Last occasion, as because the statement of the injured is not there. For that reason, the State Council has taken time.
Submitted that notice on this one, so sufficient non-appearance is delivered. The statement of the vital witness Lipu Naik
Lipu
is
Naik.
not.
Well, I received it.
This is item number 25 CRLA 1153 2023 Prashant Kumar Rao. Single petition appellant?
No, 2 persons.
How did he? Hemant.
Prashant Kumar Rao alias Hemant, and another is Shrikant Kumar Rao alias Ajay. Both are the.
Kumar Rao. So what is the date of custody?
22/5/2023.
22/5/2020. Is it your first application or earlier rejected?
First application made.
What are the offenses under which charge sheet submitted?
147.
Yes.
148. 341. 323. 325. 326. 307. 302. 149 of IPC. Read with 106 and 3 of SC Act.
3 रे कौन
3 टा कौन B ना कौन अच्छी चार्ट शीट
3-2B.
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 Okay, what is the name of the deceased?
The deceased name is, my lord, that is Akshaya.
पूरा नाम
Akshaya Panda.
Injured होची जो लिपू
Lipu.
Injured लिपू नायक. Date of occurrence?
Date of occurrence.
19/5/2023.
हाँ?
19/5/2023.
2023. ଆଉ କଷ୍ଟଡି କହିଲେ 22/5/2022 କହିଲେ
23
22 କହିଲେ
22/5/2023
22 କହିଲେ ନା ଲାଇଭ ଷ୍ଟ୍ରିମିଂ ବ୍ୟାକ୍ କରି ଦେଖ ୟେସ୍ ପଢନ୍ତୁ ଷ୍ଟେଟମେଣ୍ଟ
Can I submit?
Yes, read the statement.
Lipun.
3/5/2018 ଆମ ଗ୍ରାମର ପ୍ରଶାନ୍ତ କୁମାର ରାଉତ ହେମନ୍ତ କୁମାର ରାଉତ ଚୋରି ହୋଇଥିବା ଜିନିଷରେ ସନ୍ଦେହ କରି ମୋତେ ଗାଳିଗୁଜ କରି ଆସୁଥିଲା। ମୋର ଏହି ଚୋରି ସହିତ କୌଣସି ସମ୍ପୃକ୍ତ ନାହିଁ ବୋଲି ମନା କଲେ ମଧ୍ୟ ଶୁଣୁନଥିଲେ। ଅନେକ ସମୟରେ ମୋତେ ଧମକ ଦେଉଥିଲା ଏବଂ ସତ ମାନିବା ନହେଲେ ତତେ ଜୀବନରେ ମାରିଦେବୁ ବୋଲି ଧମକ ଦେଉଥିଲା। ଗତକାଲି ରାତି ପ୍ରାୟ 10ଟା ପାଖାପାଖି ହେବ ମୁଁ ଘରେ ଖାଇକି ଶୋଇଥିବା ବେଳେ ପ୍ରଶାନ୍ତ କୁମାର ରାଉତ ଏବଂ ତାର ସାନ ଭାଇ ଶ୍ରୀକାନ୍ତ ରାଉତ ରିତୁ ପ୍ରଧାନ ଅନ୍ୟ ଜଣେ ବ୍ୟକ୍ତି ଆସି ମୋତେ ଘରୁ ଉଠେଇ ନେଇ ଗାଁରେ ମିଟିଂ ଅଛି କହି ମୋତେ ଆମ ଗାଁରେ ଶିବ ମନ୍ଦିର ପାଖକୁ ନେଇଗଲେ ଏବଂ ସେଇଠୁ ମୋତେ ଆଉ ଆମ ସାହିର ଅକ୍ଷୟ ପଣ୍ଡାକୁ ଇନ୍ଦୁପୁର ସ୍ଥିତ ପଥର ଖଣିକୁ ନେଇଗଲେ। ସେଠି ମୋତେ ଆଉ ଅକ୍ଷୟ ପଣ୍ଡାକୁ ହାତ ବାନ୍ଧିଦେଲେ ଓ ଆଣ୍ଠେଇକି ଲୁହା ରଡ୍ ଏବଂ ପାଣି ଓ ମୁଣ୍ଡରେ ବହୁତ ମାଡ଼ ମାରିଲେ। ଅକ୍ଷୟ ଏହି ଅବସ୍ଥାରେ ଅଚେତ ହୋଇ ପଡ଼ିଗଲେ। ଏହାପରେ ପ୍ରଶାନ୍ତ ସୁକାନ୍ତ ଓ ଅନ୍ୟମାନେ ମୋତେ ନେଇକି ଗାଁ ମୁଣ୍ଡରେ ଫିଙ୍ଗିଦେଲେ ଓ ଏଇଠି ଶୋଇଥା ତୋ ପାଇଁ ପାଣି ନେଇକି ଆସୁଛି କହି ପଳେଇଗଲେ। ଆଜି ସକାଳେ ମୁଁ ଖବର ପାଇଲି ଅକ୍ଷୟ ପଣ୍ଡା ଢେଙ୍କାନାଳ ମେଡିକାଲ ମୃତ।
What is the report of the postmortem?
Postmortem report, my lord. There is no external injury. Cause of death due to the injury sustained to the head.
No
Due to
external
head and
injury.
brain injury associated with multiple muscles injury.
There are injuries, or no external injury.
No,
Vital organ.
Internal injury.
My lord. All the injuries are internal, and the injured has not sustained any injury. That is the report of the. There is no external injury over detected upon the, my lord, the occurrence witness who has
ଲିପୁ ନାୟକର କିଛି ଇଞ୍ଜୁରି ନାହିଁ ଆଉ ତାର କେତେଟା ଇଞ୍ଜୁରି ଅଛି
ତାର injury due to head and brain injury associated with multiple muscle injury as well vital organ of body resulting shock and internal hemorrhage and death.
So ଏତେ ଆଣ୍ଠେଇ ଦେଲେ ହାତ ବାନ୍ଧି ଦେଲେ ମାଡ଼ ମାରିଲେ injury କେମିତି ରହିଲାନି, so its presence becomes doubtful at this spot. How many cases are there?
No case, my lord. No antecedent.
Are the learned counsel for the appellant, learned counsel for the state? Notice sufficient, so?
My lord.
In spite of sufficiency of service of notice, none appears for the informant. Learned counsel for the appellant submitted that the appellants are in judicial custody since 22/5/2023. And they have been charge sheeted under section 147, 148, 341, 323, 325, 326, 307, 149 IPC, and section 32B of the SC and ST Act. The learned counsel for the appellants further submits that though the injured Lipu Naik stated that he, along with the deceased Akshay Ponda,
Ponda.
Akshay Ponda, were taken by the accused persons to a particular place, and their hands were tied and they were made to kneel down and assaulted by different weapons. But the medical examination report of Lipu Naik indicates that he has not sustained any external injuries, which falsifies his presence at the spot. Further submit that in absence of any specific overt act against the appellant, the bail application may be favorably considered. Land counsel for the state has produced the case diary, placed the statement of the injured Lipu Naik, so also the PM report. Considering the submission made by the learned counsel for the respective parties, nature of accusation against the petitioner, postmortem report finding, period of detention of the appellants in judicial custody, and absence of any criminal antecedent against the appellants, I am inclined to release the appellants on bail allowed.
Obliged.
Item number 26.
You have received the case record?
Yes, ma'am.
Notice also sufficient?
Sufficient.
Okay.
On 5/12.
CRLA 1154/2023. Aditya Kumar Rao. Single appellant?
My lord.
Okay. What is the date of occurrence?
Date of occurrence, my lord. In intervening night of 3 and 4.
3-4 को मास?
3 मार्च मास. मार्च 2019 में.
2019?
Sorry, 2022.
22?
My lord.
Is it your first application or earlier
My
rejected?
lord, earlier rejected and
In CRL number?
CRL number, my lord, 139 2023.
Okay, just a minute.
Granting liberty to the petitioner to renew his prayer for bail after examination of eyewitness.
Yes, there are eyewitnesses to the occurrence, and the State Council also placed the statement of one Tukuna alias Utkal Raut,
I have also
who stated how the appellant assaulted the deceased by means of bamboo stick on the head, chest, and leg, and deceased was shifted to so and so. Okay, informant also appearing at that point of time opposed. Okay, so postmortem report finding, etc. So liberty was granted to renew after the examination of eyewitnesses. So what is the position now?
My lord, eyewitness have been examined. I have given the deposition.
PW2.
Copy.
My lord.
PWA.
PW2.
PW2.
My lord, in para 3 of the
Utkal Rao.
Yes.
Accused Aditya quarrel with the bride side for shortage of mutton. Bidu Vidyadhar
Bidu hela deceased.
Told the bride side to drive out the accused from that place. Thereafter, accused returned from that place. Okay, I along with so and so returned in one two-wheeler. So first we live. Okay, Bidu told me to leave him at Tarini Chowk as he had kept the motorcycle in front of this. So I along with Bidu went near the shop. At that time, accused Aditya was sitting in front of the shop of Bira. Sukanta alias Tukan was going down the road and seeing us stayed there. Bidu told Sukant stayed there and was going to bring his motorcycle, and Bidu was going to bring his motorcycle accused Aditya assaulted. Deceased Nagon?
Bidu.
Bidu alias Vidyadharan na.
Hmm?
Bidu alias Vidyadhara Machi.
You are in custody since?
My lord, 4/7/2022.
Aditya dealt a blow. The first Aditya assaulted to his leg, for which Bidu sat there. Then Aditya dealt one blow by the side of the ear, another blow on the head of Bidu. I rose to this one. I ran out. So he has supported the prosecution case. And what is the weapon of assault, Mr. Tripathi?
Stick, my lord.
Stick.
Yes,
My
my
lord.
stick.
And what injury the deceased has sustained?
Yes, mother. There are 9 injuries.
Okay.
Due to the cause of death due to cornicerebral injury.
Okay, craniocerebral injury.
The petitioner has no intention, my lord. And so far
ଅଟା ମାରିକିନି ମୁଣ୍ଡକୁ ଫଟେଇକିନି ତାର ମଲା ଆଉ କଣ intention?
ବାଡିଟା ବି
ଅବିକା ଷ୍ଟେଜରେ ଆଉ କଣ ଦେଖାଯିବ?
ବାଡି ବି ସିଏ ଆଣି ନଥିଲା, ସିଏ ଗୋଟେ ଦୋକାନରେ ଥିଲା, ସେ ବାଡିଟା ପ୍ରିପାରେସନ ବି ନାହିଁ ତାର।
ସରିଯିବ। କେତେ ସାକ୍ଷୀ ହେଲେଣି?
2 ଜଣ।
2 ଜଣ। ଟୋଟାଲ ସାକ୍ଷୀ ସଂଖ୍ୟା କେତେ?
30।
30। ଗୋଟେ expedite trial କରିଦବା, ତାପରେ ଦେଖିବା। ଲେଖନ୍ତୁ। The learned counsel for the petitioner submitted, appellant submitted that the appellant earlier approved this court for bail in CRLA number 139 of 2023, and as per order dated 3/7/2023, the bail application was rejected. However, liberty was granted to the appellant to renew the prayer for bail after examination of the eyewitnesses to the occurrence. Learned counsel for the appellant submit that in the meantime, out of 30 charge sheet witnesses, 2 witnesses have been examined, and PW2 is an eyewitness to the occurrence. And he submits that in view of the nature of evidence adduced during trial, the bail application of the appellant may be favorably considered. Learned counsel for the state, on the other hand, oppose the prayer for bail and place the evidence of PW2 was stated as to how the appellant dealt repeated blows by means of a stick to the deceased. Learned counsel for the state further submitted that the post-mortem report indicates that the deceased had sustained as many as 9 external injuries, including the injury on the head, and the cause of death was on account of craniocerebral injury. Considering the submission made by the learned counsel for the respective parties, the nature of accusation, nature of evidence adduced during trial, and the post-mortem report finding by not inclining to release the petitioner on bail, but taking into account the period of detention in judicial custody since 4/7/2022. I direct the London trial court to expedite the trial and conclude the same within a period of 6 months from the date of receipt of the copy of the order. The petitioner is at liberty to renew the prayer for bail if the trial is not concluded within the said period.
I would have this spot is not visible from the near
ସେଗୁଡାକ
house.
ମୁଁ ୟା ବେଲ୍ ଆପ୍ଲିକେସନ ରେ ବିଚାର କରିବି ସ୍ପଟ ଭିଜିବୁଲ ନାହିଁ ଲାଇଟ୍ ଜଳୁଥିଲା ନାହିଁ. Yes, next.
Obliged.
Item number 27.
27 notice is to go.
Press matter.
Yes, yes, 27, 28, 29.
Extra copy.
3 SC
Notice, CDCA, and confirmation letter. Same order in there's other two items, 28 and 29. Yes.
Item 30.
Yes, Mr. Chan. Nobody is there.
On behalf of Mr. Chan, I prefer after vacation.
All right. Notice sufficient.
Item 30.
Yes, Miller. Now, Bar.
Learn and counsel for the state submits that notice on the informant has been made sufficient. None appears for the informant. Learn and counsel for the appellant seeks for an adjournment after Xmas holidays.
Item number 31.
May I please, Lord? Offense of 294, 341, 323, 324, 307, 34 items में लाना.
Notice sufficient है
Yes, Miller.
केबे
4 बार.
अच्छा केस डायरी पाई चंती.
Yes.
CRLA 1218 of 2023. Rajesh Moharana. Single appellant.
Yes, ma'am.
What is the date of custody?
Yeah, as per direction of this honorable court, he was surrendered on 20th October, my lord, and bail petition was
20th
rejected on
October
2nd November.
2023.
Yes, my lord. And bail
20th.
petition was rejected on 2nd November, my lord.
So, what are the offences under which charge sheet submitted?
Such filed under section 294, 341,
294.
341,
Yes.
323, 324, 307, 34 IPs and 300.
324, 307.
Yes, my lord.
34.
Yes, ma'am.
How would I go?
3-1.
3-1.
And another is 3-2V of SC/ST Act.
3-1 and 3-2V. SC/ST Act. What is the name of the injured?
Injured is Jhadeshwar Sundhi.
Jhadeshwar
Sundhi.
Sundhi. SUNDHI. Okay. What are the injuries sustained by the injured?
Yes, Miller. There are two injuries. One lacerated wound, one is stab wound. Lacerated wound is simple in nature and stab wound grievous.
Who jagare?
Over left.
Low
rib. Left low rib.
अच्छा पूथरे मान लो weapon of offense.
Thuri.
Stab who जगह रे?
Left rib.
नहीं से statement रे कौन who जगह रे?
ରେଲିଂ ଗୁଣ୍ଡା ଦାଦାକେ ଦେଖନ୍ତୁ ରାତି ଛୁରୀ ସାହାଯ୍ୟରେ ଝାଡେଶ୍ୱର ସୁଣ୍ଡିର ବାମ ପାଖ ପେଟ ଓ ମୁଣ୍ଡ ପାଖରେ ଜୋରରେ ମାରିଲା.
Monday, Babula Mohan asked on the head mile. He has a release on bail mile. Babula Mohan asked on head mile.
That is simple injury ta.
Yes.
Upon the injury ta grievous injury stab wound. Churi re marchandi petu. So how can it see achhiya करना?
Only one case, my lord. Only one case.
ये case छाड़ी ना आउटे case.
ये case टा छाड़ी आउटे 506, my lord.
506.
Yes.
Injured अवस्था ठीक अछि.
Yes, my lord. He was released on bail on.
Injured अवस्था कथा पचर.
Yes, my lord.
That ଆସିନି ସେଇଟା.
ଏଟା ମେ ରୁ already discharge ହେଲାଣି.
You earlier approached this court for anticipatory.
Yes, my lord.
There was a direction to surrender and move for bail.
Yes, sir.
Heard the learned counsel for the petitioner, learned counsel for the state. Learned counsel for the state submits that notice on the informant has been made sufficient, non-obvious for the informant. Considering the submission made by the learned counsel for the appellant that the appellant is in judicial custody since 2010-2023, charge sheet submitted under section 294, 341, 323, 324, 307 by 34 of the Indian Penal Code, section 3(1)(3) to B of the SC/ST POA Act, and after going through the statement of the injured, Jhadeshwar Sundi, and the injury report placed by the learned counsel for the state, who further submitted that the petitioner has got one criminal antecedent. I'm inclined to release the petitioner appellant on bail subject to condition that he shall appear before the learned trial court on each date when the case would be posted for trial, and shall not indulge in any criminal activities or tamper with the evidence, violation of any terms and conditions, or until cancellation of bail allowed.
Item 32.
Please use the mic properly.
Can be taken up after vacation 32.
Notice sufficient?
Notice sufficient on 23/11.
The learned counsel for the state submits that notice on the informant has been made sufficient. None appears for the informant. Learned counsel for the appellant seeks for an adjournment put up this matter after Xmas holidays.
Item 33.
Please, Your Lordship. Item 33, kindly urgent for after vacation, winter vacation.
Notice sufficient?
Yes,
I'm not paying for the informant. Petition. Petition.
Okay, Mr. Samantray, please hand over a copy of the appeal memo to the
Mail.
learned counsel for the informant.
Mail.
Okay, Mr. Matrijit Mahanti, learned counsel, files power for the informant, which is taken on record. The name of the learned counsel for the informant be reflected in the cause distance code. Let a copy of the appeal memo be served on Mr. Mahanti by the learned counsel for the appellant. And counsel for the state submits that he has received the case diary. When counsel for the appellant seeks for an adjournment, put up this matter after Xmas holidays. Yes.
Obliged.
Item 34.
Because I have submitted records showing that on the alleged date of occurrence, he was in Surat. Just a minute. Submitted that as per the order dated, he is yet to receive the instruction on the affidavit of the advocate's clerk, confirmation letter regarding so and so on the informant, case diary and instruction. Acha, goti kuhuntu, apana notice sufficient hela?
No, that is all. We have sent the letter, but
No, no.
no instruction received.
Kete guda katha apanu kuhaitela?
Yes, yes.
First hochi case diary paile?
Na. In that case, no.
Acha,
Kichi asi.
instruction about CA ta asi nathibo.
Na.
Then confirmation letter regarding service of notice on the informant.
Seta bhi yes.
Asini. Then the last one is the
affidavit.
Affidavit je se jail le thila ghatana bele अन्य गोटे state re.
Yes.
So कौन कराइबा? Next week. Sorry, after Xmas.
Yes.
All right. The learned counsel for the. पूरा pack पूरा road. The learned counsel for the state prays for an adjournment after Xmas holidays to obtain the instructions as per the order dated 11/12/2023. Please this matter. Yes.
Item number 37.
Mr. Gyanalok Mahanti.
Yes, madam. The offence on section 302 and
Phrase matter or notice has issued?
Phrase matter.
Phrase matter.
Notice jaini?
Na.
All right. Extra copy. Notice. CD. CA. Confirmation letter. Yes.
Item 38.
Notice sufficient hela?
Yes, ma'am.
Okay.
9/12/23.
And you have received the case diary?
Case diary. No. Machine.
Offense kono?
457, 380, 294, 506.
Konda?
457, 380, 294, 506, my lord.
Kebe roileni?
My lord, custody from 7/11/2023, my lord. 1 month, 11 days.
Are the learned counsel for the petition learned counsel, appellant learned counsel for the state. Learned counsel for the state submitted that notice on the informant has been made sufficient. None appears for the informant. Considering the submission made by the learned counsel for the appellant that the appellant is in judicial custody since 7/11/2023. Investigation has made substantial progress, and taking into account the nature of offense, I am inclined to release the appellant on bail allowed. Next.
Item number 39.
Yes.
Last phrase matter?
Yes, but
the notice was issued, man.
Just
let me see that. नहीं नहीं ଯାଇଥିଲା notice ଟା ଅଛି 4/12/2023 ରେ କପି ଦେଇଛନ୍ତି extra copy
extra copy भी नहीं है
Sir, I am appearing for
you
one
are
of the
appearing for
yes,
the
madam.
pass where is your V number
Already filed, madam.
kebe
2 days back, madam.
2 days back you have received the copy of the appeal memo?
Yes, ma'am.
Okay, so have you got the case diary?
Case diary is not available.
What is the offense here?
302, my lord.
302. So what is in whose name the informant has filed the wakalatnama? The name of the learned counsel?
Vijay Jena.
Huh?
Vijay Jena.
Vijay Jena. All right. Submission is made on behalf of Mr. Vijay Jena advocate that he has already filed Vinama 2 days back before the registry. Let the registry place the Vinama on record. The name of the learned counsel for the informant be reflected in the cause list henceforth. Stop. Learned counsel for the state submits that he is yet to receive the case diary and also instruction about the CA put up this matter after Xmas holidays. Yes.
Item number 40.
May I please lordship, my lord? 40, 41, 42 arise out of same FIR, my lord.
Notice?
Notice sufficient?
Notice जाइनी first.
No, no. Last
the
one,
list?
one Gyanaranjan Panda was appearing.
Wait, let me.
His name is there.
Just a minute. 1286. No, he has already entered appearance,
Yes,
Mr.
yes.
Pathi. So
Gyanananda
that
Panda.
now you are to just receive the case diary and matter to be heard.
Yes.
No, available.
No, my lord.
What is the offense here?
302, my lord. My lord has granted liberty to
Alright,
file after.
the learned counsel for the state seeks some further time to obtain the case diary and also instruction about the CA. Put up this matter after Xmas holidays. Yes.
I filed the deposition copy, my lord.
Hold on. Next. Same order in this 41, 42 also. Hello? Same as item number 40. Okay, next.
Item 43.
Notice or issue, madam.
Served and the extra copy also served on 6/12/2023.
Please wait, I'm ascertaining.
Confirmation of notice and CD.
Okay, so it is not available. So hard Mr. Badal Kumar Behera, Learned Counsel from through virtual High Court Baleswar, Learned Counsel for the state submits that he is yet to receive the confirmation letter regarding service of notice. So also the CD and CA put up this matter after Xmas holidays. Yes.
I beg your pardon. Item 41, 42, 43. My
There,
appearance may be.
the same order has been passed like item number 40. The CD
My appearance may be 41, 42, 43.
अच्छा okay. Learned खाली गोटे add कर देबे item number 40 रे Learned Counsel for the informant is present. हैला? Okay.
Item 45.
45 Mr. Himanshu Shekhar Mishra. Huh? Press matters.
My lord, I have preferred this appeal against the reaction of bail application passed by the.
It's a SC/ST matter. Notice has been issued.
No, sir. I prayed to issue notice to the victim. We issue notice to the victims.
That's all right, but you have to serve a copy of the appeal memo to the Learned Counsel for the state.
Okay, my lord.
Mr.
I have served the sir.
Okay. Let 2 copies. You serve 2 copies because one is to be retained by him. The other is to be utilized for sending notice. Let 2 copies of the appeal memo be served on the Learned Counsel for the state within a week. On receipt of the same, one shall be retained by the Learned State Council and the other copy shall be sent to the IIC so for its service on the informant CDCA confirmation letter matter to come after Xmas holidays. Yes.
Item 46.
This is permitted to withdraw with liberty to move again before the Learned Trial Court after seeing the minute charge sheet submitted.
Mr. Dwivedi and Counsel appearing for the appellant seeks permission to withdraw the CRLA to approve the trial court once again put up this the disposed of as withdrawn. Yes.
Item 47.
Mr. Chittaranjan SAHOO.
May I please your lordship? I am on behalf of Mr. Chittaranjan SAHOO. This is a fresh matter, my lord.
Fresh matter.
Yes, my lord.
So SC/ST matter. All right. Extra copy to be served. Notice, CDCA and confirmation letter. Yes.
Item 48.
Yes, Miss Nando. Fresh matter.
Yes, my lord.
All right. Same order as the previous one. Extra copy, notice, CDCA.
7 witness examine, I will also supply the copy of the
Learned
deposition.
counsel could add for the learned counsel for the appellant supplied the deposition copies of witnesses examined so far in the learned trial court to the learned counsel for the state. Yes, sir. And have you given for the court, Ms. Nanda? Okay, and also filed it for the court. Yes.
Item 49.
As if item 49 filed an interim application on the ground of illness of petitioner's mother, your lordship.
Is it coming for the first time? Or?
Yes, sir. Yes, sir, first time.
So you obtain the instruction IA number so and so. This is an application for interim bail on the ground of ailment of the mother of the petitioner.
Yes, your lordship.
Mother of the petitioner. Learned counsel for the state has received the copy of the application and seeks some time to obtain instruction on the IA put up this matter after Xmas holidays. Yes.
Obliged, lordship.
Item 50.
Mr. Jafrullah. CD available?
No.
$55, Mr. Vishwaranjan. Okay.
My lord, kindly pass over.
This is a fresh matter.
Fresh matter, case
So,
diary.
Mr. It's a fresh matter. So CD and CA is to be called for, then it will be taken out. So CD and CA, and after Xmas holidays. Yes, I will just take down the name of Mr. Kashyap, Kumar Kashyap from Virtual High Court to Balasore.
My lord, my clerk is present there. I want to file a deposition copy of one particular witness.
All right. The learned counsel for the. Have you please serve a copy on the state council also?
My lord, I have extra copy. He will serve to
All
the
right. The learned counsel for the petitioner files the deposition copy of witnesses which are taken on record. Copy of deposition has also been served on the Gotte Sakina Dita Sagi.
Gotte,
one witness. And copy of the same has been handed over to the learned counsel.
No, I have not yet received.
Whatever.
I've received now.
Okay. Yes, next.
Item 56.
Let
Yes,
six
Mr.
witnesses may have been examined in the meantime.
Fresh matter.
Fresh matter.
Okay.
I am giving copies to the.
You have received the case diary?
Yes, case diary I have received.
Give the copies.
My lord, I'm supplying 2 copies, my lord.
What is the offense here?
Offense, my lord, 302.
So you verify whether all the material witnesses examined or left
No, my
out?
lord, 6 witnesses have been examined. Last time, your lordship has directed, my lord, while rejecting the application, my lord, in the year 2021, my lord. Your lordship has directed, my lord, to file this application, my lord, after examination of the eyewitnesses, my lord.
No,
who
I
has-
just want to know whether all the eyewitnesses
No, my
examined
lord.
or
No, my
anybody
lord. 2
left out?
numbers of eyewitnesses have been examined, my lord.
Others are there.
Others are there, my lord.
What are the names of those eyewitnesses?
My lord,
If you can give the names so that the presence can be ensured so that their examination will be during this period. Those eyewitnesses examined in the meantime, they have supported the prosecution.
Yes, my lord, they have supported.
So please verify that who are those left out eyewitnesses.
My lord,
who
one,
are to be
Rakesh
examined.
Srivastav and Sonny Tirki, my lord, I have given 6 depositions, my lord.
No, who are yet to be examined. You have
My lord, that I am, sir.
okay. Just verify and give
My
a
lord.
slip. I'm just mentioned Siddhave. The London Council for the state has received the case diary. You have received the case.
Yes, case diary I have received.
London Council for the petitioner has filed the deposition copies of 6 witnesses, including 2 eyewitnesses. However, he submits that so and so are the eyewitnesses, Joda Debe, who are yet to be examined. In view of such submission, let inspector in charge of plant site police station appear before the London Trial Court, that is First Additional Session Judge Raurkela, in ST case number 66 of 2021, on or before December 29th, receive summons in respect of the eyewitnesses and ensure their attendance on the date fixed. Put up this matter after Xmas holidays. If the witnesses are examined in the meantime, London Council for the petitioner shall file the certified copy of their deposition on the next date, giving copy to the London Council for the state. Yes, and keep it in the 3rd week so that because yes. Mr. Naik, give the names after verification. Yes.
My lord.
Item 57.
Yes.
Yes, it's a
Yes,
fresh matter.
my lord.
20B2C, my lord.
Lordship, I would like to apprise my lord that I am in JC from approx 3 years, Lordship. And out of 6 persons that were apprehended on the spot, 4 are already on the bail. And the impugned order is on the page number 33, Lordship. The impugned order expressly says that the charge sheet has been filed and the charge has been framed. Lordship, in the page number 33, bottom para.
Yes,
it
sir,
says,
that's all right.
Lordship, but the 3 years of judicial custody and only charge has been framed, Lordship.
No,
And
I'm just. What is the date of custody?
Lordship, it's 1/2/21, 1 February
1st
21.
February 2021.
Yes, Lordship.
So,
and 6 persons were
all right,
apprehended.
you have not obtained the case
No,
diary.
case diary is not
Get it. And these men are outsiders or what? Mr.
Yes, Lordship.
Manohar?
Yes, Lordship.
Yes, from Patna.
Yes, Lordship. He is from Patna.
That obtain instruction about the address verification also.
Lordship, in the meantime, can we submit the document for the local
Okay,
security?
you file.
Lordship,
The London Council for the state submits that he is yet to receive the case diary, and further submits that the petitioner belongs to state of Bihar, and he may be given some time to obtain instruction about the correctness of the address furnished by the petitioner in the cause title. In view of such submission, let the Superintendent of Police Malkangiri make necessary communication with Superintendent of Police Swanso and obtain instruction in that respect. London Council for the Mr. Sam Manohar, London Council appearing through virtual mode, submitted that the petitioner is in judicial custody since 1/2/2021, and even though charge has been framed but not a single witness has been examined in the trial court as per his instruction. Let a status report be called for from the learned trial court. Put up this matter. Give a date. Yes.
The phone number of the learned, my senior, so that I will send the documents. The phone number of my learned senior.
Take down the if the learned counsel for the petitioner gives the names, addresses, and documents of two local sureties to the learned counsel for the state, same shall be verified through the inspector in charge of this MB 79 police station, and report to that effect shall also be produced on the next date. So,
We not make it number or email ID, anything else.
Misra, please give the number so that he will either Gmail or something so that
Yes,
he will
Lord,
send it to
anything.
you for that.
I'll give it now, Malaj.
If it is available, or Mr. Manohar, please give your phone number so that he can communicate
Yes,
you
Lord,
later.
my number is on the
B
mail
number
application.
Number
is there, Lord.
Okay. Yes.
I'm obliged.
Implication has surfaced.
You have
But in
received
dying
the case
declaration, specific
sir.
overact has been attributed to.
just a minute.
Is there in a connected matter? If your lordship may keep it to tomorrow, I can get
All
it.
right. Put up this matter tomorrow along with Swan. Yes. Yes, next.
Item 60.
And also copy of the bail order in which manner bail has been granted.
Give it. Tomorrow it will come. Yes. Item number 60, Mr. Panda.
After vacation.
It a
Fresh matter.
All right, CD, CA, and raise for after vacation. So will come after vacation. Yes, after Xmas holidays.
Item 61.
May I please? CD available?
Yes, case.
My lord, this is the fourth bail application. The first was dismissed. The second was I was allowed for interim bail for just for a month. On the third bail, I was allowed for 3 months of interim bail. Lordship, the JC is almost of 4 years, and the one accused of the same matter, co-accused bail has been disposed on last week Friday.
You have
Lordship.
received the case diary.
Case diary yet to receive.
And
File-
what is the stage now?
Lordship, out of 17, only one witness has been examined. And Lordship, the
Out of total number of witnesses?
Lordship, out of 17.
How
17.
many?
Only one has been
Only
examined.
one. All right.
Yes, Lordship.
All right.
And co-accused bail has been disposed by my Lord on the last week.
The Learned
He has
Counsel
been
for
allowed the
the
bail.
state submits that he is yet to receive the case diary. No, yet to the first date of. He may be given some time to produce the case diary. So also the take instruction about the criminal antecedent. The Learned Counsel for the Mr. Sam Manohar, Learned Counsel appearing through virtual mode, submitted that the appellant was taken into the petitioner was taken into judicial custody for the first time in this case on what is the date?
Lordship, it's 31/12/2019. 31/12.
2000. All right. And he has been granted interim bail for some time. And he, after availing the same, he surrendered at right time. And he has instruction that out of 17 charge sheet witnesses, only one witness has been examined. Put up this
Local
matter
person.
after ensuing Xmas holidays. Status report we called for. CDB obtained in the meantime. Yes.
Obliged, Lordship.
Item 63.
Millard, here 20B2C.
Fresh matter.
Fresh matter, Millard.
Right. CDCA status report. Yes.
Item 64.
64, please, my lord.
Fresh matter.
Item 68.
May I please your lordship, my lords? My lords, earlier case was disposed of, my lords. In the meantime, petition is in custody, my lords. 13/1/2013, 10/2020.
CD we have not yet received.
Mr. Mahapatra, it's a fresh matter, so he is to obtain the case diary and criminal antecedent.
My
And
lords,
it will come after Xmas holidays.
my lords, 31/10/2020 already custody.
Okay.
Obliged, my lords.
CDCA status report movie.
Obliged, my lords.
Item number 69.
Mr. Abhishek Das, fresh matter.
Fresh matter, CD we have not yet received.
Xmas holidays, so CDCA status report. Next.
Item 70.
My lord, kindly
May I be
pass
pardoned,
over.
my lord?
Okay, Mr. Das, the CDCA is not available, so I have adjourned to
Lordship.
after Xmas holidays.
Lordship, if I
And
may,
I
your
have also
lordship,
called for the status report. Yes.
grateful, my lord. If I may point out, my lord, this so far as those petitioners are concerned, it was earlier dealt with Justice G. Satpathy, your lordship.
No, but if it is at any point of time dealt by me in respect
Lordship.
of the accused, it will come to me, and I find that number of bail petitions are there, and yes, it has been disposed of by me earlier.
Lordship, lordship.
Yes, next.
Grateful, grateful.
Okay, item 70.
My lord, 70 kindly pass over.
No, case diary is available.
Yes, case diary is available.
So, what is the offense here?
No, it's 20B2C, 25 and 29 of the NDPS.
So it's an outsider or local man? Bihar.
Bihar, your
To
lordship.
get that instruction about the correctness of the address.
My lordship.
So that is to be ascertained. Okay, he's a man from so and so, and the SP of so and so shall make necessary communication. Those usual orders. So CD has been received like this. CA has to be obtained and address verification is to be made. Okay. All right.
Item 71.
After Xmas holidays, huh?
Pardon, my lord.
Yes, 71.
Pardon, my lord. My item was 53.
Huh.
Just
53. It's a case diary is not available. So fresh matter, I have asked him to produce the case diary and also the criminal antecedent, and matter will come after Xmas holiday. Okay. Yes. Next.
71.
72.
71.
May I please your lordship? My lord, in this case, your lordship, the similarly situated co-accused persons, your lordship has
CD is not.
my lord, subject to your lordship acceptance, only 2 line of submission, your lordship.
Sorry, let the case diary come. Yes, next.
Item number 72.
72. Balakrishna Roy. So
Case diary is available.
Your lordship, may I pray one thing, my lord? 72 and 78 arising out of the same case, my lord.
So 78, we'll see when the matter reaches, we'll see that. This
Grateful, my lord.
let it be taken up with 78. Okay. Call the matter serially.
Item 73.
73 case diary में call for 20B2C.
Yes. Okay.
And status report.
CD, CA, status report after winter holidays. Yes.
Item 74.
74, your lordship earlier rejected. I pray, my lord, I will sort the deposition copy in the meantime, my lord. Some of the witnesses examined.
Diary we are yet to receive.
And your lordship call for the status report.
CD and CA. You will supply.
I will supply.
And counsel for the petitioner submits that some witnesses have already been examined in the trial court, and you will supply the deposition copy to the learned counsel for the state, and also file a set of deposition for the court. Status report be called for.
After
After Xmas holiday, yes.
Item 75.
May I please, Your Worship? Out of 7 accused persons, 6 are already released on bail.
Yes, case diary is there.
Yes. You have got those bail order copies?
Yes, I have attached next.
Okay. So, is it your first application or earlier rejected?
Yes, first application.
No. Then what is this number which has been annexed this bail order, this BLAPL 4489? So that is not in respect of the petitioner, it is for somebody else.
Yes.
No, you have earlier approached learned counsel. You approved this court for bail in BLAPL number 7255 of 2021.
Yes. And then, yes, I have mentioned.
This is the second one.
Yes.
What order was passed in that application?
That application I have not.
Is it not been uploaded in the High Court website? Have you not verified? Acha bahar kalai. BLAPL 7255 2021. Yes. It was disposed of on 15/2/2022 as it appears. And you are given liberty to file a fresh bail. Aisa share kar dijiye na.
Yes, sir.
Sabu jinso kaya padibo na kon. Our learned counsel will see that. Has it been done?
Yes, Your Lordship.
Okay. So, Mr. Misron, he says that some of the co-accused persons have been released on bail. Is perhaps claiming parity, verify the case record and the bail orders of those co-accused persons, whether he stands on the similar footing. Have you verified it?
Lords, let me also be served a copy of the depositions, Lordship.
Okay.
So 7 witnesses have already been examined.
Have you got these copies with you? Click on. You have received the bail order copies?
Yes, bail order, yes, annexed, Your Lordship.
The learned counsel for the petitioner submits that some witnesses have been examined in the trial court, and he will supply the deposition copies of those witnesses to the learned counsel for the state within a week, and file a set of deposition for the court of this matter after Xmas holidays. Learned state counsel submit that he has received the copy of the case diary, so also the bail orders of the co-accused persons. Yes. Okay.
Item number 76.
Item 76, kindly pass on.
Victim be examined the learned counsel for the petitioner.
Tag the.
Then it's all right. Status report. Next.
Item 77.
On behalf of Mr. Patnaik, my lord, kindly take it after Xmas. Back as
Achi case diary achi?
Fresh matter, my lord.
Okay. CD, CA. Achi na? Again. CD available. Kal chhad diyo. Learned counsel for the petitioner 6 for an adjournment. After Xmas holiday. CD available.
Obliged.
Item number 78.
May it please, Your Lordship.
That case diary that is available in 72.
72, my lord.
Okay. So,
May it please your lordship.
is
My
it
lord,
a first application or earlier rejected?
earlier rejected, my lord. This is third application, my lord.
Just a minute. So,
Flag A may kindly be considered that is the first bail application.
flag A.
My lord. BLPL number 1799 of 2019.
Okay, where it is been written that in view of the eyewitness account of Shita Martha, who is the informant as well as mother of the deceased, Maheshwar Martha, and the role attributed to the petitioner, your bail application was rejected in 2019.
My lord.
So what has happened in the meantime? How many witnesses have been examined?
18 number of charge sheeted witnesses examined, my lord.
So,
Here the, my lord, here the prosecution case, my lord. 10 eyewitnesses are there, my lord.
No, who is the eyewitness who has already been examined in the trial court?
10 eyewitnesses examined, my lord.
Okay.
But
So
8 number
what
of
they have stated
eyewitnesses,
against you?
1 and 2.
All right, Mr. Mishra,
My lord.
see what this PW1 Sita Martha, relying on whose statement the bail application was rejected, what he has stated against this
May I
petitioner,
read, your lordship?
Niranjan Maharana alias Gajana.
May I read, your lordship?
Yes.
It's at page 15, your lordship.
Page 15. Okay. I was in my house and my son went out of the house and was standing outside the house. As it was very hot inside the house, I heard the shouts of my son and I came out of my house and saw accused Bhola slaying my son with sword. Guna was assaulting Maheshwar by Bhujali.
Just a minute, go slowly. So who are the two petitioners here? No,
My lord,
the other counsel is not present. So your bail application is Niranjan Maharana.
My lord.
Niranjan Maharana petitioner. Deceased is Maheshwar.
Maheshwar
Martha.
Martha, my lord.
And yes, so he said, I saw the accused Bhola slaying my son with a sword. Your nickname is Bhola or not?
No, my nickname is
another
Gajanan, my lord.
Okay, then Guna was assaulting Maheshwar.
Gajanan was assaulting by Chapad.
Gajanan was assaulting by Chapad and Shankar was assaulting Maheshwar with an iron rod.
My lord.
So then the accused persons, after assaulting, fled away from the spot. Maheshwar had sustained bleeding injury, so and so. Then Maheshwar has immediately so and so. I had gone to 15
I
days.
had also gone to the hospital with Maheshwar, my lord. Thereafter, my lord, your lordship may kindly
four
consider.
names which he has stated in paragraph number 2.
My lord.
They are the names of the name of this petitioner. Niranjan Maharana is not there, or he has any nick?
No, Niranjan Maharana is there. Gajanan equal to Niranjan Maharana, my lord.
Guno is item 72, your lordship, Prasanto Balwant Rai. And Gajanan is Niranjan Maharana.
Niranjan Maharana.
I'm saying Niranjan Maharana is known as Gajanan.
My lord.
And Gajanan has assaulted by means of a chapad. So what is your submission?
My lord, your lordship may kindly turn to the FIR, my lord. Complaint of the complainant, that is Sita Martha, page number 13 and 14. ଖାଇ ସାରିବା ପରେ ଗରମ ଯୋଗୁଁ ଦାଣ୍ଡକୁ ଆସି ବାହାର ପବନରେ ବୁଲୁଥିବା ସମୟରେ କେତେକ ଦୁର୍ବୃତ୍ତ ମୋ ପୁଅକୁ କଟୁରୀ ଭୁଜାଲି ଆଦି ମାରଣାସ୍ତ୍ରରେ ଆକ୍ରମଣ କରିଥିଲେ। ସେହି ଆକ୍ରମଣ ଯୋଗୁଁ ମୋ ପୁଅ ଚିତ୍କାର କରିବାରୁ ମୋ ଘର ଭିତରକୁ ଆସି ଦେଖେ ତ ମୋ ପୁଅ ରକ୍ତାକ୍ତ ଅବସ୍ଥାରେ ପଡିଅଛି। ମତେ ଦେଖି 3-4 ଜଣ ଦୁର୍ବୃତ୍ତ ଦୌଡ଼ିବା ସମୟରେ ସେମାନଙ୍କ ପଛରେ ଚକ୍ରକୋଟ ଲେନ୍ ଆଡକୁ ଦୌଡ଼ିବାକୁ ଲାଗିଲେ। ସେମାନେ ଦୌଡ଼ି ପଳାଇଲେ। ତାପରେ ମୁଁ ଆସି ପୁଅର ଅବସ୍ଥା ଦେଖି ସାହି ପଡିଶାକୁ ଡାକିଲି ତାକୁ ଟ୍ରିଟମେଣ୍ଟ ପାଇଁ ନେଲି, my lord. There is no name against FIR ରେ
FIR your name is there. He came to learn. She came to learn from others. That is how your name is also there. She is not an eyewitness as per the FIR, but there are other eyewitnesses.
All the eyewitnesses are turned hostile, my lord. PW 4, 5, 6, 10, 11, 12, 15, 16, all are hostile, my lord.
Yes, Mr. Mishra, what he says that as per the FIR.
In the 161 also, my lord.
Just a minute, if for as per the FIR, PW1 cannot be accepted as an eyewitness and other eyewitnesses have not supported the prosecution case, then what is your submission about, because how many witnesses have been examined?
18
18 have been supplied to me.
Yes, 18. And you are taken into custody when?
My lord, since 20 May 2018, my lord.
2018.
My lord, 2 times interim bail granted by the learned court below, and once interim bail, 3 months interim bail granted by this honorable court.
Charge sheet under section?
Charge sheet under section 302-34 of IPC, 25 and 27 of the Arms Act. For a while, 161 may kindly be perused.
Wait.
Your Lordship, the weapons of offense have also been seized here. They have been sent for the chemical examination report, but that has not yet been received.
No, that is all right, but have you gone through that FIR which was presented
Yes,
by
Lordship, I went through
PW? There he says that Ketteko Durbuto, again yet that those words have been used. Then he said, ସେଠାରେ ଚିକିତ୍ସାଧୀନ ଥିବାରେ ମୋର ପୁଅ ମୃତ୍ୟୁବରଣ କରିଥିଲା. Then he says in the next page, ମୋର ପୁଅ ମରିଯାଇଥିବା ନୀଳକଣ୍ଠ ମୋତେ ଫୋନ୍ ପ୍ରକାଶ ଥାଉ କି 15 ଦିନ ତଳେ ମୋର ପୁଅ ମହେଶ୍ୱର ଘର କହୁଥିଲା ଯେ ବୋଉ ମୋ ସାଙ୍ଗର ଘରକୁ ସୁଆଂଶୁ ଗଜାନନ ଇଜ ଦି ପ୍ରେଜେଣ୍ଟ ବମ୍ ପକେଇଛନ୍ତି. ମୋ ପୁଅକୁ ପଚାରିଲି କାହିଁକି ରେ ପୁଅ ସେମାନେ ବମ୍ ପକେଇଲେ, ସେ କହୁଥିଲା ଆସାମୀମାନେ ତା ସାଙ୍ଗକୁ 1 ଲକ୍ଷ ଟଙ୍କା ବଟି ମାଗୁଥିଲେ. ସେଇ ଆସାମୀମାନଙ୍କୁ ମୋ ପୁଅ ବୁଝାସୁଝା କରିଥିଲା. ସେମାନେ ମୋ ପୁଅକୁ ଧମକ ଦେଇଥିଲେ ତୁ ଏଥିରେ ମୁଣ୍ଡ ପୁରାନା, ଯଦି ପୁରାଇବୁ ତୋର ଜୀବନରୁ ମାରି ଶେଷ କରିଦେବୁ. ସେଇ ଆସାମୀମାନେ ହେଲେ, then he has given the names. So that relates to a previous incident. But so far as on the date of occurrence is concerned, he has stated that some culprits committed the offense. Now, in the court, he has named not only the petitioner but also the other co-accused persons, and that part he has stated. So that is why he said that, and the other eyewitnesses suppose would have supported the prosecution case because 18 witnesses have been examined. You have seen the evidence. They are not saying anything against this particular man, or have they stated anything?
The rest of the eyewitnesses, as per the 161 statement, they've all turned hostile.
That is all right. Hard the item. This would be item number 78. The London Council for the petitioner submitted that the petitioner was taken into judicial custody on 25/2018, and he has been charge sheeted under section 302/34 of the Indian Penal Code, section 25 and 27 of the Arms Act. The petitioner has been granted interim bail for some time by this court, so also by the London Trial Court. He further submitted that 18 witnesses have been examined so far, except PW1, Sita Martha, the informant of the case, who is the mother of the deceased, Maheshwar Martha. Nobody has stated anything against the petitioner.
PW2 has also stated.
PW2 is the father, my lord.
1 and 2 both has stated.
Acha, PW1 so and PW2 Ramachandra Martha, who is the
Father of the petitioner.
of the deceased, have stated about the participation of the appellant petitioner in the assault of the deceased. The London Council for the petitioner, however, submitted that when the first information report was presented on 18/5/2018 by PW1, there, she has mentioned that some culprits committed the crime and assaulted the deceased. She has not named the petitioner to be one of the assailant of the deceased. Deceased or na kono?
Maheshwara Martha.
Maheshwara Martha on the date of occurrence. The Learned Council further argued that if PW 1 and 2 were the eyewitnesses to the occurrence, then the first information report would have reflected the names of the accused persons, including the name of the petitioner in it, to be the assailant of the deceased on the date of occurrence. But since the same is conspicuously absent, it is very difficult to rely on the statement of PW1 and PW2. Learned Council further submits that in view of the period of detention of the petitioner in judicial custody and the progress of the trial and the nature of evidence adduced in the trial court and the conduct of the petitioner in complying with the earlier orders of the interim bail, the bail application may be favorably reconsidered. Learned Council for the state has produced the case diary, placed the evidence of the witnesses examined so far in the trial court. Considering the submission made by the Learned Council for the respective parties, nature of evidence adduced, period of detention of the petitioner in judicial custody, conduct of the petitioner in complying with the earlier interim bail orders, I am inclined to reconsider the prayer for bail and direct the petitioner to be released on bail allowed.
Grateful, ma'am.
Huh? No, he is not present. So just mention that none appears for the 72 for the petitioner put up after Xmas holidays. This order was passed only in 78. 72 is adjourned because nobody is appearing.
My lord.
Okay.
May I pray one thing, my lord?
Yes,
Another
next case.
co-accused matter also pending, my lord.
Yes,
Seat
next case.
kindly be.
Item 79.
May I plead, sir? In this case, the NTPS case, out of 3 accused persons, 2 have been released by other coordinating on bench, my lord. And your lord, this is the third round application on behalf of the petitioner, my lord. In previous 2 applications, your lordships granted 3 months interim.
So it is 20B2C.
My lord.
And you are in custody since?
Since 28/9/2020, my lord.
28/9/2020
My lord.
Last time केबे जाइथिले bail?
Last time
interim bail जो
on 23/3/23, my lord. In BL number 558.
So surrender ठीक समय रे कले.
My lord.
वर्तमान position कौन case?
The rejection order itself shows that 5 witnesses have been examined, my lord.
Status report मगेजन. Learned Council for the state submits that he has received the case diary. है Learned Council submits that the petitioner has been released on interim bail twice, na?
My lord.
Twice, and after availing the same, he surrendered at right time. And he has instruction that only 5 witnesses have been examined so far in the trial court. Status report be called for. While submitting the status report, the Learned Trial Court shall specifically indicate as to whether, after availing the interim bail period, the petitioner surrendered at right time or not. Put up this matter after Xmas holiday. Yes.
Blessed.
Item 80.
CD not present. CD not there.
Lordship, may I submit some?
Yes.
Lordship, there are 8 accused persons. 2 are on regular bail. 3 are on interim bail, Lordship. And out of 16, 6 witnesses has been examined. 3 are the officers, police officers of the raiding team, and 2 other witnesses.
Let him get the instruction, the CD, CA, and also address verification. All right. Yes. Next, after Xmas holidays. Yes.
Item number 82.
Item 82, my lord, pray for after vacation.
Case diary available achi?
My lord.
My lord.
Lordship,
CD available and
can I-
counsel for the petitioner seeks for an adjournment after Xmas holiday. Yes. Next.
My lord, in the meantime, can I submit the documents of the surety?
You can submit. Yes. Next.
My lord, I'm
Item
obliged.
83.
May I please, your lordship?
Yes. CD available. 83, madam. Madam.
My lord. Here in this case, the offense alleged under section
Yes,
20.
just- You what is- Okay. Is it the first application or earlier rejected?
Earlier rejected.
So what is that number? 1846.
8057 of 16.
Huh?
Of
This
this,
number ta aschi kon lekha hai BLAPL 1846.
another co-accused person.
Okay, let us see that.
Right.
This is Sabitri.
Putta.
So it appears that 1851 of 2019 also you filed. So what is the date of custody?
My lord, 8/7/2016.
What is the offense?
20B2C, my lord, 177 kgs ganja.
What is the stage of the trial?
My lord, out of 24 charge sheeted witnesses, 17 witnesses has been examined as on 27/2023.
And have you been released on interim bail?
No, my lord. Other co-accused released.
Okay. The learned counsel for the it is coming for the first time, no?
My lord.
The learned counsel for the petitioner submitted that the petitioner Sabitri Putta is in judicial custody since 8/7/2016. And in the trial court, out of 24 charge sheet witnesses, she has instruction that by 27/7/2023, 17 witnesses have been examined,
As per rejection order.
which is also clear from the rejection order. In view of such submission, let a status report be called for, matter be placed immediately after the Xmas holidays. Yes.
Obliged.
Item 84.
My lord, I am in the virtual mode, my lord. In this case, my lord, Annexure 2.
CD available? Madam.
In this case, my lord, the bail was rejected when Annexure 2, page 10, your lordship. I have sought the bail on the ground that similar accused persons already in the split case has already been acquitted, man. Since the petitioner, let's say the petitioner is surrendered before this court after the direction of the surrender court in Annexure 1, page, my lord, Annexure 1, page 8.
You earlier approved this court or is it the
No,
first application?
First time, my lord. I surrendered before as per the your lordship direction.
When?
Annexure 1, page 8, your lordship. Annexure 1, your lordship, page relevant page 8, your lordship is directed.
No. When you surrender, I just want to know the date.
Page 9, your lordship. My surrender on 15/9/23, your lordship.
15/9/2022.
23. 23, my lord. 23.
59-23. Okay.
23, your lordship. On the plea that,
So-
my lord, similar already on the same case, my lord. Plead case, the other accused person have already been acquitted. Page NSR 5,
It's
page
a case
105.
under section 302 and other offenses.
My lord,
Maoवादी case की?
my lord.
हाँ.
Your lordship, NSR 5, page 105. Already the accused persons on the self-same case.
It's a 2007 case and you are an absconder for about
Well, I have-
16 years.
I have not been named in the FIR.
No, you may not have been named, but you are being charge sheeted and co-accused
I was-
persons face trial. So you are aware that
not aware.
case is going
Not
on.
aware.
Now
I was not
16 years absconder, no bail. You face the
I-
trial, get acquitted.
I was not aware, my lord, because
Okay.
in this your lordship, nobody
Alright.
was named in.
All right.
Subsequently, in the charge sheet, they found, and ultimately, when I came to know, I surrendered.
Okay. Heard the learned counsel for the petitioner and counsel for the state. The case is of the year 2007 and the FIR was lodged on 22/6/2007. The petitioner surrendered before the trial court, before the court below on 15/9/2023.
Yes.
In the meantime, some of the accused persons, after facing trial, acquitted by the
Right.
trial court.
NSR 5.
It's a case under section 302 of the Indian Penal Code and other offences. Since the petitioner was an absconder for 16 years, I'm not inclined to release the petitioner on bail. The petitioner, the learned trial court shall do well to expedite the trial. Yes, next.
Item 85.
May I please? This is my
CD available, Mr. Sixty. 64, madam. 64, sorry. BLAPL number 12100 of 2023. देखिए दवा DLAPL number हाँ ठीक है जी शिव शंकर नायक ठीक ठीक with सेटा संग्रह शिवा ना एक्समास हॉलीडेज पर हाँ ओके
Okay.
Item number 86.
Paper afterwards.
case diary अच्छी no madam. All right, CD, CA, and also praise for adjournment. So after Xmas holiday, yes.
Item 87.
Press matter. Hello. Press matter item 87.
87
नहीं नहीं अपनों पर case diary copy भी देना
नहीं कॉपी देशन को जो
अच्छा give another copy to be served, CD and CA to be obtained after Xmas holiday. Yes.
Item 88.
Mrs. Das.
May I please, my lords?
अच्छी case
My-
diary. Okay.
My lord, in this case, my lord, petitioner earlier released on bail by interim bail.
We'll
by
take
the-
up the matter after lunch. Yeah.
My lord, this matter also.
Yes.
89.
Yes.
I may be pardoned, my lord.
Yeah. Two application. There are two revision petitions. You called just one. In view of the foregoing discussions, I am of the humble view that the London trial court was not justified in convicting the petitioners under section 420, 468, 471, read with section 120B of the Indian Penal Code. And it was also not proper on the part of the London Appellate Court just to quote the evidence of few witnesses and abruptly coming to the conclusion that it agreed with the conviction judgment passed by the London Trial Court. It is well settled that in a criminal appeal, a duty is enjoined upon the appellate court to reapprise the evidence itself, and it cannot proceed to dispose of the appeal upon appraisal of the evidence by the London Trial Court alone, especially when appeal has already been admitted and placed for final hearing. The duty of an appellate court is to look into evidence adduced in the case and arrive at independent conclusion as to whether the said evidence can be relied upon or not, and even if it can be relied upon, then whether the prosecution can be said to have been proved its case beyond reasonable doubt on the said evidence. The presumption of innocence with which the accused starts continue right through until he is held guilty by the final court of appeal, and that presumption is not weakened by a conviction in the trial court. In the case in hand, the quality of exercise which was expected of the appellate court to be undertaken has not been done, and that was the reason for which this court, in its revisional jurisdiction, in the interest of justice, was constrained to have a relook at the evidence and assess the evidence as an exceptional case to set right the patent defect. In the result, the conviction of the petitioners under section 420, 468, 471, read with section 120B of the IPC is hereby set aside, and the petitioners are acquitted of all the charges, both the revision petitions are allowed. Yes.
Item number 89.
May I please, my lords? My lords, before filing this petition approach your lordships earlier in bill number 3629, 2023, and this honorable
You have
please to
received
grant
case diary, Mr.
my lord 3 months and the surrender in time, surrender certificate I have annexed, my lord. Annexed to the surrender certificate. Petition custody, my lord, 22 June.
You have recently been released on bail. Must have surrendered in November.
And thereafter, my lord,
Right,
surrender.
put up this matter after ensuing Xmas holidays. The status report be called for. Learned counsel for the state submit that he has received.
My lord, the order copy page 18 also the law and trial court mentioned out of 20 witnesses.
We'll see that.
Witnesses only 5 witnesses examined, my lord.
All right,
Yes.
all right.
And that order here, law and trial court has mentioned, my lord.
Yes, next.
Item number 90.
Wait. The last will order copy is filed, which is taken on record. Yes, next. CD available?
No, madam. Your lordship kind of a second time, madam.
All right.
Your lordship kind of order sheet of the last 6 month order sheet.
CDCA status report. Next.
You kindly see it, madam.
After Xmas, let him bring that.
It kept on record, madam.
Yes, yes. Order sheet file taken on record. Yes, next.
Item 91.
CD available?
Okay.
OPD 92
Yes.
OPID.
OPID, yes, sir.
On the record, I found that there is no offense under the OPID Act. According to instruction, I verified the record. There is no offense registered under OPID Act.
So, but why then, who has rejected it?
Miller designated court rejected. Some of the cases have been transferred to the designated court without the OPID Act.
So if it is pending before the designated court, maybe that one of the offense would be definitely OPID Act.
No, other cases have been transferred by the session court to the OPID court. In view of the pendency of the cases.
Oh.
Yes.
Some cases are being, other cases apart from OPID Act case that has also been tried by the. So yes, if there is no OPID Act offense, then you are to please return that copy to Mr. State Counsel so that he will obtain instruction. Is there any offense under OPID Act?
Yes, my lord.
But he says no.
Rejected the annexure 2, my lord.
Annexure 2, where it is mentioned?
Annexure 2 is a rejection copy of the.
Yes, where it is mentioned that the offense is OPID Act. The court is OPID Act, court, designated court. But since that some of the such offenses cases are maybe lesser in number, that is why to that court, as per the order of this court, the session judge has sent some of the other cases. Although that court was required to try only the offense under OPID Act, but since there is less number of cases under that act, so some other cases have been directed to be tried by that court. So accordingly, he says that the offenses are under 419, 420, 467, 468, 471, 120B. No OPID Act case is there. So now the State Counsel is to obtain instruction. The Learned Counsel, this matter is coming for the first time?
Yes, madam.
Okay. Please tell the name, Learned Counsel.
Anil Kumar Naik.
Anil Kumar Naik, Learned Special Counsel for the State of Orissa in OPID Act matter, submits that he has received instruction that in the case there is no offense under OPID Act. Even though the bail application was rejected by presiding officer designated court OPID Act, Cuttack. In view of such submission, let the copy of the bail application which he has received be handed over to the Land Council for the state.
Already.
I have
And let the Land Council for the which he has already handed over the copy. He handed over to them. Handed over the copy of the bail application to the Land Council for the state, who seeks some time to obtain the case records as well as instruction about the criminal antecedent. Put up this matter after Xmas holidays.
pardon me. No, in this case, the present petition is in no way connected.
That will only consider after the receipt of the case diary. Yes, next.
Item number 93.
93, my lord, jail in
CD available? No, madam. Okay, get the case diary, criminal antecedent after Xmas holidays.
Item number 94.
Maybe.
Okay, after Xmas holidays. Yes.
Item 96.
Is it available? CD? Yes.
May I please, my lord? I'm through virtual mode.
Yes.
My lord, in this matter, this is a fifth bail application, and petitioner is in JC since 11/11/2019. And my lord, out of 11 witnesses, as per instruction, only 2 witnesses has been examined, and both the witnesses had totally negated the alleged prosecution story of search and seizure.
So let me call for the status. The Learned Counsel, Ms. Kiran Pandey, appearing through virtual mode, submits that the petitioner Gopinath Khilo is in judicial custody since 11/11/2019, and she has received instruction that out of 12 charge sheet
11,
witnesses, only 2 witnesses have been examined so far in the trial court. Learned Counsel for the state has received the case diary. Have you been released ever on interim bail?
Yes, my lord. We have released 2 times on 3rd and 4th of bail application
Okay.
for 3
She
months.
further submits that she jo tankari compensation beluku lekhidebe eta. Hala. The Learned Counsel for the petitioner further submits that twice the petitioner has been granted interim bail by this court or the trial court?
By this court, my lord.
By this court. And you surrender at right time after having.
Yes, ma'am. On second, 4th bail application, my lord, there is a delay of 2 months as he is not well, but he has surrendered after 2 months.
After availing the same, he surrendered at right time. Status report we called for. List this matter after Xmas holidays. Yes.
Obliged, ma'am.
Item number 97.
My please, Your Lords. Praying for an adjournment.
CD available? No, okay, CD, CA, and after Xmas holidays, as prayed for by the Learned Counsel for the petitioner. Yes.
Item number 98.
CD available? No, madam. Okay. CD, CA, after Xmas holidays. Yes.
Item number 99.
May I please? Here the
Yeah.
present petitioner has voluntarily surrendered being implicated case under section 302, my lord. Of the
CD available?
My lord. 302 IPC. I have
As of last token on 14/12/2023, my lord, I have appealed for the informant. That has not reflected, my name has not been reflected.
Have you received the copy of the bail application?
No, my lord.
We will take up this matter. You have received case diary. We can take up this matter tomorrow or day after tomorrow.
Tomorrow, my lord, day after tomorrow.
All right. In whose name the informant has filed the VNAMA?
Santilotam, my lord.
कहाँ नाम है advocate? हाँ?
Amlan Shaktipa.
Amlan Shakti Paul PAUL. It is stated by Mr. Amlan Shakti Paul that he has entered appearance for the informant by filing VNAMA on Kebe
And on 14/12.
14/12/2023. In view of such submission, let the registry place the VNAMA on record. The name of the Learned Counsel for the informant be reflected in the cause list henceforth. The Learned Counsel for the state has received the case diary. Put up this matter tomorrow.
Obliged.
ऐसे वकालत नोटा नहीं आसियो मगेइकिन शामिल कर दो एटा टिके आगुरु टिके करे देबे हां यस
Item number 100.
Ma'am. Lord, in this case, the occurrence took place on 9/2/2020.
CD available?
Lord, on 9/2.
Yeah, just a minute.
You lost.
Is it the first application or earlier rejected?
Second application.
So what is the first?
Your Lordship, this is the my lord, liberty was granted to the Your Lordship to renew my prayer.
File? Kuda? 11,058 ସେଗୁଡା ତ?
Your Lordship.
Okay. Then what is it? The dispose of what was the date on which it is disposed of?
Disposed upon 27/7/2022.
Okay, 302 so and so. It was the prosecution case so and so. Okay, basing on this. The detailed order was passed and it was rejected.
Your Lordship.
So what happened? What is the development?
That development, my lord, I have filed the deposition copy. Out of 53, my lord, 52 have already been examined, 1 left, and 19 witnesses have been declined, my lord.
What is the total number of witnesses as per charge sheet?
As per charge sheet witness, 53.
53.
My lord.
So how many of them have been examined?
52 examined.
Decline is
sorry, 34. 34 have been
34 examined. Decline?
Decline 18.
18.
My lord.
Okay, so you have supplied the deposition copy.
My lord.
So what is your submission?
My lord, submission is there is no eyewitness.
What evidence has come on record against you?
Nobody, my lord. Informant also.
The deposition copy.
Your lordship.
Where is that? Deposition copy.
Informant is the PW3.
Where? Mr. Das, have you verified the deposition copy?
No, not verified.
So we'll take up tomorrow. Verify.
Your lordship.
Please this matter tomorrow.
Publish.
How much nahi to? Nah, sure.